Here, Joy.
Thank you so much, Susan and Marianne. It's great to see you. And it was really interesting hearing how many of you have your own, not only professional, but also personal um, situations with special need children. I am here to talk about divorce mediation, but I want to say also that I was the guardian for 10 years for Count Basie's daughter, who had severe special needs. She had severe cerebral palsy and couldn't walk or talk. And her parents died when she was 40 and she outlived them for another she died when she was 78. They had been told that she wasn't going to survive past the age of 21. But because of a confluence of circumstances, she was able to make it that long, which was really remarkable. Um, okay, so I'm going to share the screen and interrupt me at any time if you have questions. I'm fine with taking questions as we go along. I guess I should introduce myself a little bit more and say, well, I can put this up just to begin with, right? You can see that. Um, I have been a divorce mediator for 19 years. I am, there, okay. Um, Before that, I represented children in family court. A lot of them also had special needs. Um, and so that's sort of what the background that I've come to it. I have never litigated divorces, nor do I ever want to, but I really see the advantages of mediation for all couples who are getting divorced, but it's not for everyone. So we'll talk about that a little bit. And I practice. I live in Nyack, but I most of my clients are in New York City. So there are different ways of getting divorced, and I'm not sure why this is. So one is what we call kitchen table. If there's not a lot to figure out and the people get along, they can sit down and just figure it out at the kitchen table. Um, Sometimes some people call it the Starbucks approach. This would probably not be appropriate for people with kids with special needs because there's too many decisions to make. Mediation, and I'm going to show you some diagrams in a minute about what these things kind of look like. But collaborative law is a sort of spin-off of mediation where both people have attorneys in the room while they're talking to each other. But the trick is that one, they agree that if it ever goes to court, they're going to use different attorneys. So it's safe to talk in front of the other person's attorney. And two is that the collaborative lawyers are trained mediators. And so again, they're like in mediation, it's the parents themselves. I'm going to refer to them as parents rather than parties, but because we're talking about kids. It's the parents who are making the decisions, not the lawyers, and the parents are talking directly to each other. And the goal is to help the parents come to an agreement. And the collaborative lawyers are there to provide information and support, but they're really also there to help the parents come to an agreement. So I'm only going to refer to mediation through it in the talk, um, but collaborative law is sort of fall. There's a lot of things that are about mediation that are also true about collaborative law. Negotiated settlement is where each person goes to their own lawyer and the lawyers talk directly to each other and try to work things out, or at least work out the sticking points. Um, a lot of times in a negotiated settlement, something is filed in court, but it's not like there's a trial. And then litigation, at least in New York, it's very expensive and takes a very long time. So it's really for people who have a lot of resources or when there's just no way to do one of the other things. And those are the divorces that you hear about, cost $50,000 or $100,000 or something like that. Okay, so when I'm going to show you these slides, sort of these diagrams, I want you to think about who's talking to whom. So this is sort of what mediation looks like. So I don't know how interactive you want to be. Like, if we were in a classroom or like sitting around in a circle, I would say I would ask you questions, but maybe you don't want to be that interactive. So, but if you look at it, the spouses are talking directly to each other as well as to the mediator, right? So the mediator can talk to both spouses at the same time. When I mediate, I work with both people in the room. I don't go back and forth. Some mediators do what they call shuttle mediation. So the mediator will talk to one spouse, then talk to the other. But that's not how I mediate. We're all talking to each other, and everybody has direct access. And if one person has a question for the other, they just ask it. In collaborative process, the attorneys, remember I said they're also trained as mediators, but it's a four-way meeting. So the spouses are talking directly to each other, they're talking to their lawyers, and the spouse one can talk to spouse two's attorney, and spouse two can talk to spouse one's attorney. So that's not usually permitted in any kind of litigation process. And that's why it's important to sign that agreement in the beginning that says, if this goes to court, we're going to use different lawyers, because then they won't be able to hold something that somebody said in a confidential setting against them, the other person in court. In a negotiated settlement, each person talks to their own attorney and the attorneys talk to each other. But if you look, this is the first slide we see where the spouse one and spouse two don't talk to each other. So even though they were married maybe for 30 years, now they're not talking to each other, at least not officially through this process. They might call each other to scream at each other, but they're not talking. And in litigation, the attorney, there should be actually an arrow between the attorneys, because they still do talk to each other. But if you look at this, this is more hierarchical, right? The spouses talk to the attorneys, and the attorneys talk to the judge, and the judge is the one who's making the big decisions. And I see that there's something in the chat, but it's going to be hard for me to read. Oh, love the visual graphics. Oh, great. So here are some things about the mediator. The mediator is a neutral, not a judge, right? The mediator is not making decisions. The mediator's job is to understand each person's perspective, and in the process of asking them questions, a lot of times they're helping each person really think about what it is that they want and need and articulate it. They're also, in the process of doing that, the other person, the other spouse, a lot of times gets to hear things in a way that they haven't heard before. So they might have been having the same fight for 20 years, but when you have that fight, you just sort of shut down and you just don't listen. But if your spouse is then explaining things to the mediator, to a third person, often they kind of hear it in a different way. The mediator is an advocate for the process, but not for either person, and cannot give legal advice, because she's there not as a lawyer, but as a neutral person. So where it says advocates for each person and party in the process, that is a concept called positive neutrality, where the way I put it when I'm talking to two people is, I want to be there for you and I want to be there for you. And I want both people to feel supported in the process. But like I said, but it's very important to maintain that neutrality. And it's really there to help the parties or the parents understand each other. The participants have to be willing to really be there in good faith and really be there to try and come to an agreement. They have to be willing to say what it is that they want and need, and to listen to the other person. They have to be open to understanding the other person's point of view, and to understand that there's a difference between agreeing with it and acknowledging that they're saying what they're saying. So if the other parent says, I want to have the kids on Thursday, and you totally don't agree with that, you should not have the kids on Thursday, but at least you're acknowledging that she's saying, I want to have the kids on Thursday. Um, and again, stop me if there's anything I'm saying that's not clear. Um, the other thing that's necessary for mediation is you have to be willing to share all relevant information. A lot of time that's financial, but it might be other things too. That doesn't mean, no, one of the other things about mediation I didn't put on here is that it's very future focused. So it's not focused on blame, it's not focused on fault, it's focused on what's going to happen going forward. Um, and people who are mediating have to be responsible for the outcomes and to solve problems together and really meet work together to meet the needs of the child first and really keep the child's needs, especially with special needs kids, keep the child's needs front and center. Um, so again, it's appropriate where people are basically willing to do all this stuff. It's not appropriate if there's domestic violence, intimate partner violence, coercive control, if there's a big power imbalance between the parents for other reasons, if one parent just shows that they won't do what they say they're going to do. If one parent is not realistic about the situation, is saying that they're going to spend a lot more money than they have, or something like that. If there's addiction or mental illness or other things that will prevent them from thinking clearly, or where I say too little emotional regulation. So I've done mediations where somebody just sits and cries the whole time or screams the whole time, and they're not ready really to sit down and come to an agreement. And sometimes that can be because there's just been a trauma. Um, so I just found out that my spouse is having an affair, or I just found out, somebody just died or something like that. That's not a good time to mediate. Um, so that doesn't mean that the person isn't right for mediation. It just means this not right now. Um, so why is this coming up? I'm sure you know, there's an increasing number of special needs kids in general, and it's becoming more something that's talked about more in the divorce community because of that. The parenting plans can be more complex than typical divorces. I feel like I'm preaching to, like, you guys all know this better than I am, but um, there's there's higher stakes for children and parents. And there's this constant balance, right, of safety versus independence for the parent, for the child. And and parents are constantly have to be involved. I mean, when I was listening to you, you're talking about kids who developmentally are not able to be independent in a way that other kids the same age might be. And that obviously goes into adulthood. Um, so I think I can kind of skip these, but the limits of litigation are that the people who are making decisions, the attorneys and the judges, are not as familiar with your child. They're never going to be in any kind of divorce, and they don't have the time to really understand what's going on. And so I always say to parents, you're the experts on your situation. They might know what the law is, but nobody's going to understand the child's strengths and weaknesses, the strengths and weaknesses of each parent as well as you do. So that's one of the limits of litigation. They just don't have the time to really understand what the child's individual needs are. The other thing is that when you go to a judge, you usually only go once because it is so expensive and you don't want to spend your rest of your life in court. And so there might be an appeal or something like that, but it's a one-time thing without a a process or a protocol laid out usually for how to modify the agreement without going back to court. The orders can be rigid, you do this, you do this, you do this, you do this, and it may not be well thought out given your circumstances. It's obviously an adversarial structure, so I always say that if people who are getting divorced start out here, by the time the lawyers get finished with them, they're way out here, right? They're much farther apart than they were when they started. And part of that is sort of the nature of litigation is we're all taught in law school to be zealous advocates for our clients. And if each spouse comes in and their lawyer is saying, I can get you this deal or I'm going to get you this deal, and the lawyer feels that their job is to get the best deal for their client, which is usually financial, where does the kids' needs come out in all of that? And they're not thinking about the needs of the family as a whole. And that's one of the big differences with mediation. I always say, I'm trying to help you figure out, given your circumstances and the strengths and resources of your family, what's the best for the four of you or the five of you or however many. Um, so mediation can be better suited but for the nuances of the situation and toward the complexity of the situation. Can really look at what the child's needs are, what's happening now, what needs are being met, what needs aren't being met, how are you going to make decisions in the future? How are things going to be modified? All of that can come up, and there's room to talk about in mediation, and there's room to really explore in mediation. So beside the mediator, in collaborative or in mediation, there are other professionals who might be helpful. So some are child specialists, and these are people who really sort of understand child development, understand divorce, and can sort of help if the kids are having trouble dealing with the parents' divorce or dealing with going back and forth or dealing with the different households. The child specialists, they're mental health professionals who can help go through. And some of you are those people, right? And some of you are coaches. They can help. And that's often used in any kind of mediation, and help the parents work together effectively and communicate with each other and solve problems going forward. But they don't usually make decisions for the parents. They can work with the parents, but the parents are still the ones making the decisions. The other people who can be helpful, also usually mental health professionals, sometimes lawyers, are parenting coordinators. And they particularly work in high conflict divorces, and they will make decisions. And they might be written into a court order saying that if you guys can't decide, it's going to go to a parenting coordinator. And then a divorce coach is somebody who can help. Usually, I think, maybe you guys can correct me if I'm wrong, but my understanding is that you usually work with one parent or the other to help them deal if they're having a hard time dealing emotionally, if they're very angry or very upset, help them like sort of settle down enough in the meeting to be able to make decisions and work productively. Um, Other professionals that the parents might use, and you probably know all of this, is a financial specialist to help the child apply for government benefits and help set up a special needs trust or something like that, so that the parents can pay for things without affecting the child's benefits. Educational specialists, so what happens when the child outgrows their school or day program. A special needs attorney. So in New York, it's a really big deal that the city where you have to have enough money to put up the first year's tuition, but a lot of times if the city won't pay for the child's needs, then the parents will sue the Department of Education and get reimbursed, send their kids to a private school, sue the DOE, and then get reimbursed. And that often requires you need a special needs attorney who can do that for you. And then, of course, medical professionals or other people who are involved in the child's life, and they can also help with making decisions, right? I mean, if the child's therapist would be consulted, or sometimes the medical doctors would be consulted for different things that will come up. So Lily Vasilev, who is a friend of mine, I reached out to her. She's also the parent of a special needs child, and she specializes in financial planning for divorce professionals. She has a great checklist, and when I'm done, I'll put her a link to it in the chat for how you can get it. But part of her checklist, she's asking these questions. Do both parents have the necessary equipment? Are both homes equally equipped, or can they be adjusted to be equipped for the needs of the child? How does the child do with transitions? So I think especially children with autism might have a hard time with transitions. So where a regular parenting plan might encourage a lot of transitions going back and forth, maybe you wouldn't want it as often with a child who has a hard time with transitions. Um, do would it be appropriate or helpful to let the other siblings who don't have special needs have some time away, and the parents also, is it so that everybody can kind of get the attention that they need? Um, you might want to put in, I always in my mediated agreement say if something changes in the future, whether it's for child support or parenting plan, how are they going to deal with it in the future? Will they come back to mediation? Will they try to talk about it with themselves? If they're going to go to mediation, how many times should they go before anybody can file something in court? And then the big question, and I think this is hard, and this is one of the reasons mediation might be hard, is that in almost all of my mediations, the parents have joint decision making. But if one parent is really very actively involved and really understands the child's needs thoroughly and the other doesn't, it might not be appropriate to have joint decision making. So that's really a big question. And then there are different things that you decide in any divorce, but there, in particular with special needs kids, there might be for child support. There in New York, we have what we call basic expenses, which sort of covers food, clothing, shelter, and that's usually a dollar amount each month, regular dollar amount. But then there's what called add-on expenses that change all the time. So there might be extraordinary medical expenses or caregiving expenses or educational expenses. And that might be more what I say where the action is. Like the basic amount might not be that big of a deal, but how much, what percentage are the parents going to pay for these extraordinary expenses? Is it 50-50? Is it something else? Um, there might be alimony required because if one parent can't work because they're taking care of the kid, maybe alimony would be important. And it might not be for the amount of time. You might need it for a longer amount of time if that parent is really never going to be able to work while the child is a minor. Then there are estate planning considerations, which I think everyone's aware of, but can be hard to face. If you're dealing day to day with a kid who just trying to get them through the next day, the next week, the next month, it can be really hard to think about what would happen if I die? What would who is going to take care of the child? Are they going to go to an institution? Are they going to be set up? Is there enough money for them? I mean, these are really hard questions, right? But these again are things that you could address in mediation, um, and and would be helpful. Not the parents I work with a lot of times they're just like we just can't deal with that, and I have to respect that. But it is something that could be if they do want to deal with it or when they do want to deal with it. Mediation could be a great tool to help them think it through. Um, Mediation builds coordination that it help between the parents. Can help with the communication between the parents. It can help tone down the conflict. One of the things that you're doing in mediation is if somebody comes in and is very angry and upset, one of the mediators sort of modeling the behavior of helping them express what they need without being so angry, but can also create sort of a model for how parents can solve problems together. And that's really lovely, which litigation doesn't do, right? Litigation sort of assumes, like we said, it's a more adversarial stance. Mediation is also more flexible, and so things can change. A lot of times when I'm mediating with a couple, I'll say, let's try this parenting plan. You can try it for a few weeks until we meet again, see how it's going. Give the kid time to get used to it. Give you time to get used to it. If it doesn't work, we can always change it. And so it can be more flexible. Um, Lowering conflict is better for everyone if it's possible. It can be a very flexible way to help parents create a detailed parenting plan that accommodates the needs of their children and themselves. So I still have extra time, a whole 10 minutes, and I'm happy to answer any questions. And
I had a question about when you were talking